So by definition in the dictionary, catastrophic is causing great damage and suffering. How would you define it though, Rob, in our perspective?
Well, certainly great damage and suffering is apt. But beyond that, I think it's something that lingers, it stays, it doesn't, it may improve to a certain extent, but it is definitely affecting someone's life in a big way, and it's not going away.
Like, I'm thinking of an example where our client, he was on a scooter and somebody made a left-hand turn in an intersection and broke his leg, and it was a really bad break, and they had to put in hardware, They open it up, internal fixation with screws and everything. Yet what happened was he developed what's called complex regional pain syndrome, which is like a nerve injury, and you're very familiar with it, I know, Rob.
Yeah.
And so
that's simplifying it to call it a nerve injury.
Oh yeah,
it's almost like an autoimmune response where the body does not recognize healing, and there's pain signals just keep getting sent to the brain, and the brain doesn't, correct it, and it's a real horrible situation.
So the reason I mention that is because, you break your leg, and if it's set right, maybe, everything's fine, and you go on with your life ultimately, and it's not affecting you.
Right.
Whereas when you have this other syndrome attached to it, which is lifelong, and there's really no cure for it. No cure for it either. Then it kind of morphs into being a catastrophic injury.
Right. And oftentimes it's really the family in those kinds of settings. It's the family that feels the justice and feels the closure better than the person with that injury, because they're just their life has been turned so far upside down.
But you make an interesting point, though, because that catastrophic injury just doesn't affect the person who's injured. It affects the whole family unit.
Like a giant, what they call that, the ripple or the butterfly effect or whatever. Yeah.
So, Rob, who can be held liable for causing a catastrophic injury to one of our clients?
Well, it depends on the circumstance, because some are very simple. There's a driver going down the road and they're not paying attention, and they smash into the rear of the person ahead of them, and that person comes to us, right? So that person who caused that collision is liable.
And so when we're focusing on who's responsible or liable, I mean, it could be the driver. Could be
if we're talking about a car accident.
Yeah, if we're talking about a car accident, or the employer of the driver. It's called vicarious liability.
Very, very usually.
And then there's
if they're working.
And let's say the driver is operating a vehicle that has a defect. Let's say there's a defect in the tire or whatever. That's product liability. And then let's say that the crash occurs on a highway.
That they're doing construction, or they didn't quite, factor on the way people might be using that highway correctly.
And proper warning signs. So now you got a governmental entity.
Yeah.
So to recap, could be an individual, could be the employer, could be a product liability, could be a governmental entity. All those possible defendants.
Right.
That have to be held accountable.
Or at least looked into.
Certainly.
Yeah. So Larry, if someone, let's just talk about a car collision again, a car crash, and someone gets very seriously hurt, what do they have to prove? Do they have to prove the other guy was negligent?
Yeah, we have to prove that someone acted below the standard of care. It could be, not following the rules of the road, making an unsafe left-hand turn when cars are coming towards you, or following too close and hitting a car from behind. However, there is an.
But you got to prove it. That's the thing.
There's a burden.
We have the burden. If we're the plaintiff, if we're the person representing the person who got hurt, we have to prove the other guy, the other person, could be a woman, okay, did something wrong. They violated a vehicle code section, or just a safe driving. But anyway, I interrupted you.
No, I know. It's just that there is kind of a interesting facet of that, let's say somebody's driving down the street and you're hit from, and you're minding your own business and you're hit from behind. Turns out that the person that hit you had a heart attack and they didn't know anything about their heart condition beforehand. That might be considered an act of God. So even though you're rear-ended, there's this weird exception to some of these.
Yeah, and the insurance company may say, forget it, go fish.
Yeah.
And you'd have to, that could be a tough situation.
I had a case like that. That's why I brought it up.
Yeah.
Although I proved that the person who had the heart attack knew about his heart condition.
Knew that they shouldn't be driving.
Exactly.
Yeah.
And so
that's getting
where the
creative.
negligence- Yeah.
That's what it takes.
And I got those records. I got the medical records. So Rob, let's say the scenario is this. The person involved in let's say, collision is determined to be partially at fault.
Who determined this?
Well, let's say there is an allegation of somebody being partially at fault. Can that person still file a claim against the other party?
Well, the short answer to that is, as you know, is of course. And my favorite example of something like that is, I think this was one of your cases. There's a guy going south on Las Virgenes,
That's right.
Malibu Canyon, and cars are coming toward him, but they're pretty far away, and he makes a left turn. Now, you're on the hook. If you turn left in front of somebody else, and ordinarily it's on you, it's your fault, end of story. This is a very catastrophic injury though, big crash. Why? Because there's a guy going north who's going about 100 miles an hour.
In his racing Porsche.
Yeah. And so, okay, yes, the left turn guy, our client was comparatively at fault, partially at fault. Shouldn't be turning left unless it's absolutely clear. But it's not unreasonable to believe he had the time to make the turn, not realizing this guy is going that fast. And this guy is speeding so fast, he's a menace. He's as they say, an accident waiting to happen. And so, yeah, he's on the hook for, some of that, liability. And under California law, we carve up liability. It's not always just 100%.
Comparative negligence,
Right.
we call it. Yeah, so our client may not get a full recovery, yet he or she is entitled to a recovery.
Right.
Nevertheless.
So, yeah, you can, even if you're partially at fault, you can file a claim, and you should, if you've had something happen to you that is affecting your life, and especially if it's a serious or a catastrophic harm. Sometimes, even if you have the lion's share of fault, it's worth you filing that claim, pursuing that action, because your situation is so bad. What do you think someone should do? They've had this terrible event, whatever it might be, and they get a catastrophic injury. What do you think the first thing they should do is?
Well, the obvious is to get proper medical care. Call 911, get the ambulance, get the care.
I think most people in that setting, someone's calling the ambulance for them.
Yeah, probably.
Yeah.
And there's, if you're in a catastrophic type of situation, it's hard to document what happened, although we do want people to document, the scene. Let's say it's a crash, and the automobiles and their positioning, because I've had cases where the photographs were taken and later it proved, to be beneficial for the client, or they have a dash cam and the dash cam captures who's at fault.
Yeah.
But when you're seriously injured in that kind of situation, there's not much you can do. You could call, family or friends and have them come out, and if you're awake enough to,
if you're aware,
and tell them, look, can you take some photographs of the scene,
right?
Or capture the witness, because those witnesses become critical at times, to get the names of those witnesses, and then ultimately, maybe at a later time, because I've done this just recently, is you surveil the area and see if there's any video surveillance capturing what had happened, because that makes a total difference in the case. So Rob, let's say somebody's in a catastrophic situation, a catastrophic injury. How long will it take to resolve a case like that?
Well, as you know, we're at the mercy of the courts, right? So I always tell people, look, it just depends on the circumstances, because if someone is very seriously hurt and there's an insurance policy on the other side that is clearly insufficient to cover the breadth of this loss, they're probably going to be, offering that. They're going to be, please take it, right? So that could be a matter of, a couple months, But if you're in for a fight, if they're disputing liability, or they dispute the amount that is that you're looking for this client, if there's some kind of argument going on between the two sides, then you're in the court system, you're in litigation. And these days it can take 1 year to 2 years to get your trial date. And it's just the way it is. The courts are packed. We're here in LA County. It's the largest court system in the country, I believe. Maybe New York City is bigger. So maybe we're the second largest. But it's, dozens and dozens of courts.
I have a case right now where the judge said, well, how long ago did this occur? It was like 1.5 years ago. And in that judge's mind, he felt that was a young case.
Yeah.
So that cases that have been lingering for maybe 3 years or more are going to get their trial date first.
Right.
And it depends on the jurisdiction, because I have a case in locally, and that courtroom just opened up. And so the judge is saying, look, I can get you to trial within 6 months.
Yeah.
It's a brand new courtroom.
You just never know.
Other courtrooms in the same jurisdiction, LA County, will say, well, you know what, we got a trial date for you in 2026.
Yeah.
It's like, oh, well, that's
just the way it is. Hey, Larry, so when a client comes to you and they say, hey, how much is my case worth? What do you tell them?
I tell them it's too early to tell.
Well, what if it's not too early to tell?
Usually
what if you're like 2 weeks before trial and they ask you that?
Well, if it's 2 weeks before trial, we've pretty much formulated what the medical expenses are, right, what the person has lost in income, if applicable. And then we also have the intangible, which is the pain, suffering, inconvenience, anxiety, mental suffering, those aspects, which is up for grabs. But
oftentimes the most valuable part of the case.
Right. And then sometimes what we do is we compare other jury verdicts to our case, and then we have a feel for it. So at that point, I will give the client a range of what the case. But if they ask right at the beginning of the case, how much is my case worth? It's like, I don't know, because that person may end up having injections. Let's say it's a spinal injury, injections and or surgery.
Right.
So,
down the line, who knows what's going to happen down the line? Or they may wake up one day and feel perfectly fine, which is great. I always wish that for somebody, but that's how the value, I hate to say it, but the value of someone's case often depends on how miserable they are and how terrible their situation really is.
How it's affect their quality of life.
How does it affect their quality of life, their ability to earn income? So all those things are put into the mix.
So Rob, somebody's involved in a catastrophic injury and the attorney fee.
Right.
What does it cost to hire an attorney to champion on behalf of that person?
Well, it really should, in essence, in reality, cost nothing. It should cost zero. And you know what I'm talking about, but I'll explain this. When you hire lawyers like us, we work on a contingency fee. We don't get paid by the hour. We only get paid if we have a successful resolution of the case for our client. And so what does that cost? It depends on the value of the case, because we're getting a percentage at the end of the case. But in the interim, we're not just working for nothing, as we go along, and investing hours and, dozens and dozens and dozens of man hours and woman hours, but we're also investing money, because to do a very serious case, like a brain injury case we've been talking about, like a case where someone can't walk anymore, or can't, they're relegated to a bed, or they even have that terrible pain disorder you were talking about before. You need experts. Those experts cost thousands and thousands of dollars each. Sometimes you need accident reconstructionists to put the thing together.
An engineer.
Engineers. They may want to do animations so they can explain, or you may need medical animations or medical illustrations. Maybe there's multiple witnesses or people you got to talk to, you got to take their deposition. Maybe some of them you want to do video of. All of that costs a ton of money. So it's not uncommon for us to inject, I use that word, but I mean invest multiple six figures in a very serious case. Sometimes you could have $500,000 or so in a very serious catastrophic case, and it's okay. We don't mind doing it. We're happy to do it. We're willing to do it, and we have the means to do it.
Well, we do it on we do it on a contingency.
Oh yeah. Well, so what are we charging? We're charging a percentage, but in putting in money all on the premise that we're going to win and we're going to get a good result for that person. Along the line, it costs them nothing.
I see. So now, and tell me if you agree with this. The reason that it's done on a contingency or percentage basis as opposed to hourly is, in my mind, and tell me if you agree, is that a person who is injured, especially in a catastrophic setting, how are they going to pay for a lawyer on an hourly basis?
Cannot.
Yeah, it's...
So there may be 1 out of 100 that could maybe afford to pay a lawyer, but I don't know, maybe not even then,
So this is our way of giving somebody legal representation and making sure that their rights are protected.
Give them a fighting chance.
Right.
If you can't find a lawyer who's willing to invest their time and their money in your case, without you doing anything but trying to get well and trying to get better, then you don't have the right lawyer, And I can't really think of any lawyer that does what we do that doesn't have that same setup. But that's the way it is, and that's the way it should be.
So, Rob, you can drive down any street and you see lawyer billboards. Why doesn't our firm have billboards like that?
That's really just not our bag. We are a community law firm, a boutique law firm, as you might say. We've been here for many, many years. We have this vast array of people that we have served in the community throughout the Los Angeles area and Southern California. And I think we would just rather get our business through word of mouth, through referrals from people that know who we are and know the quality of services we provide.
And we get referrals from other attorneys too, that perhaps don't want to litigate the case and go to trial.
All kinds of people like that that just know us, So we just don't feel the need. I've never felt the need to have billboards or,
TV
bunch
ads.
of TV ads. And look, I all the power to them,
yeah.
Right? If that's what those kinds of firms want to do, that's great. That's good for them. It's just not who we are.
Right. I think you lose a little bit of the personal touch by doing that, and we want the personal touch.
We want to know our clients. I don't know if I say it like this, but I want to know their stories intimately.
Yeah.
I want them to be someone who feels comfortable if they or someone they know or love finds himself in that situation again, feels very comfortable coming back to us.
If they trust us.
Right.
And they know that we're sincere and that we're going to do work as hard as we can to get them the result that they deserve.
So word of mouth, that's what I think it works for us.
Right.